Welcome back to the deep dive. Today, we are taking what I think is the ultimate shortcut to legal literacy. We're plunging straight into the real mechanics of English contract law.
Mm,
We're going to be dissecting the language of deals, not just what a contract says, but what the law actually allows it to say.
that's right. And for anyone, you know, negotiating a deal, signing a lease, or even just clicking I agree online, understanding this stuff is just essential. We're going to show you how courts decide which promises are binding guarantees and which ones are, well, just noise.
Our mission today is crystal clear. We're extracting the crucial knowledge about what separates a legally binding term from a mere statement. And maybe more importantly, we're going deep on the control mechanisms the law uses to police those sneaky clauses.
And one's designed to limit or exclude liability altogether. And the real power of this, for you, listening, is in the application. If you understand where liability truly lies, you can assess the real risk and the actual protection that's embedded in any agreement. This isn't just theory. This is the framework that determines if you have any comeback when a deal goes south.
Okay, so let's start right at the beginning, the negotiation table. Two parties are talking, making statements about, say, product quality or a timeline. In English law, there's this massive legal chasm between a contractual term and what we call a mere representation. What fundamentally separates those two?
It really all comes down to intent. A contractual term is a statement that the parties, or specifically the person making it, intended to be a binding promise.
So it's part of the actual agreement.
It's integral to the agreement. And if that promise is broken, that is a breach of contract. Simple as that.
And when a court finds a breach of contract, the primary remedy is to award damages based on the expectation interest, right? They want to put the injured party in the position they would have been in if the contract had been performed correctly. It's about fulfilling the promise.
Exactly. Now, on the other hand, you have a representation. This is a statement made during negotiations to induce the other party to enter the contract. It's the sales pitch, basically.
Okay.
But it's not intended to be a binding, guaranteed part of the final deal.
So if that statement turns out to be false, let's say a seller claimed a machine could handle 1,000 units an hour, but it only does 500. We're not dealing with a breach of contract anymore. What's the alternative?
Well, we shift into the world of misrepresentation. And this is a huge practical distinction. The remedies here are fundamentally different.
How so?
With misrepresentation, the primary remedy is often rescission. The contract is just unwound. Both parties go back to where they were before the contract was ever made.
So you just rewind time, essentially.
You rewind time. And the other big difference is that damages are focused on the reliance interest. So, reimbursing the money you spent relying on that statement being true, rather than compensating you for the profit you expected to make.
That is the critical nugget of insight right there. The difference between expectation damages, fixing the future, and rescission, unwinding the past, hinges entirely on whether that initial statement was a term or a representation. It's incredible.
It really is. The same words spoken across a table can have these radically different outcomes.
Can you give us an example?
Sure. It's the difference between saying, this car will last 5 years and I guarantee it as part of this sale, versus saying, in my experience, this model usually lasts 5 years. The first one sounds very much like a term.
And the second is more of an opinion, a representation.
Precisely.
So how does a court, after the fact, figure out what the intent actually was? What factors help them decide if a statement crossed that line from mere inducement to a binding term?
Well, courts look at 4 main practical things. First, timing. If the statement was made immediately before the signing of a written contract, it's more likely to be seen as a term that was, maybe just overlooked in the paperwork.
Okay, that makes sense.
Second, importance. Did one party make it really clear that without this statement being true, they would not have entered the contract at all?
Oh, right. Like if I buy a house specifically because the seller guarantees the roof was replaced last year, that guarantee is highly important to me.
Exactly. Third, reduction to writing. If the final agreement is all written down and a key statement made orally during the talks is left out, well, that strongly suggests it was just a representation. The written document is usually taken to be the entire agreement.
And the fourth factor, which is probably the most relatable for everyone listening, expertise.
Yes, this is where the surprise often lies. If the party making this statement has specialist knowledge, say a car dealer talking about an engine's condition, that statement is much more likely to be treated as a binding term than if it were made by a private, non-expert seller.
So the law holds the expert to a higher standard of certainty.
It does.
Okay, so we've drawn the line between the binding promise and the sales pitch. Now let's pivot and address the fine print. The clauses everyone fears, the ones designed to wipe away all the liability the law just assigned, we're talking about exclusion clauses.
We are. Exclusion clauses, or sometimes they're called exemption clauses, are terms put into a contract specifically to limit, restrict, or even entirely exclude one party's liability for certain types of breaches or harms
You see them everywhere.
everywhere. On the back of a parking ticket, in a multi-million-pound software license. They are ubiquitous.
They sound inherently anti-consumer or just anti-fairness. Why does English law even allow them if they're so prone to abuse?
That's a great question. Because they can play a legitimate role in risk management and pricing. A supplier might offer a product at a 10% lower price if the buyer agrees to carry some of the risk of failure, for instance.
I see. So it's about allocating risk.
Exactly. Freedom of contract allows parties to do that. The issue arises when that risk allocation is forced upon a weaker party because of unequal bargaining power.
And that's why the law has to step in. It ensures that while we have freedom of contract, we don't have freedom to impose arbitrary contracts. The law imposes specific controls over these clauses to police that imbalance.
Absolutely. The moment a party tries to exclude liability for major faults, the law starts to scrutinize it very carefully. We operate on a two-tiered statutory approach, historically led by the Unfair Contract Terms Act of 1977.
Let's focus on that first pillar then, the Unfair Contract Terms Act 1977, or UCTA. This act is foundational, particularly in the commercial and B2B world. What is its main function?
UCTA 1977 subjects most exclusion clauses to a really stringent test of reasonableness. The key thing to remember about UCTA is that it mainly applies when parties are negotiating on one party's standard written terms of business.
You mean the non-negotiable boilerplate agreement they hand out to everyone?
That's the one, the take it or leave its contract.
So if two huge corporations individually negotiate every single line of a completely tailor-made contract, UCTA is less likely to intervene.
Precisely. It's designed to protect the party who is sort of forced to accept the standard terms. UCTA requires the court to look at whether the clause was a fair and reasonable one to include, given the specific circumstances known to the parties when the contract was made.
Let's get practical here. What does reasonableness really mean in the eyes of a judge? It sounds so vague.
It's more detailed than you'd think, actually. The Act's guidelines spell out several factors. First, the relative bargaining strength. If one party is much larger or more powerful, the clause is more likely to be deemed unreasonable.
Okay.
Second, did the injured party receive an inducement to accept the clause? For example, we exclude liability for delays, but in return, we give you a 20% discount.
So if I consciously traded my right to sue for a lower price, a court might see that exclusion clause as reasonable.
Exactly, because you gained something in that exchange. They also look at custom and industry practice, and whether the customer knew, or really ought to have known, the term was there.
Was it hidden in tiny font, or was it clearly pointed out?
Right. And UCTA also has some absolute no-goes, doesn't it? There are some things you just cannot exclude liability for no matter what.
Absolutely. The strongest example is death or personal injury caused by negligence. No clause can ever legally exclude liability for that. Full stop.
And another one, in contracts for the sale of goods, UCTA prevents sellers from excluding fundamental implied terms.
And that's a bit of a technical term. What do you mean by an implied term regarding title?
It's simple, really. Yeah. The law implies a term into every sale contract that the seller actually owns the goods they're selling and has the right to transfer them to you.
Right.
Without UCTA, a shady seller could put a clause in saying, oh, and we exclude all liability if it turns out we didn't actually own these goods. UCTA says no. You cannot contract out of that core promise.
That distinction is crucial. So UCTA 1977 is clearly designed to inject a dose of fairness, particularly where there's a standardized agreement being imposed, mainly in a business context. But now we have to shift to the consumer sphere, which has its own specialized defense mechanism, the Consumer Rights Act 2015.
Yes, the CRA 2015. This is the modern, robust, protective shield for the individual consumer. If you, as an individual, are dealing with a business, a B2C transaction UCTA doesn't really apply to exclusion clauses anymore. The CRA takes over, and it applies a much stricter standard.
And what is that standard? How does it differ from UCTA's general reasonableness test?
The CRA 2015 focuses on unfairness. The test is whether the term, and this could be any term, not just an exclusion clause, causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer.
A significant
A
imbalance.
significant imbalance contrary to the requirement of good faith.
That language, significant imbalance and good faith, sounds even broader and more protective than UCTA's focus on process and bargaining strength.
It is. It really is. UCTA kind of asks, was it reasonable to agree to this clause given the negotiation? The CRA asks, is the content of this clause fundamentally fair to a consumer? It's a focus shift from procedural fairness to substantive fairness.
A very different question.
Very different. The Act even provides an indicative gray list of terms that are likely to be deemed unfair, like disproportionately high cancellation charges, or terms allowing the business to just change the contract whenever they want.
Let's try to visualize this with a consumer example. Think about a gym membership contract. Say it states, the gym is not responsible if any of your property is stolen from the lockers, even if the theft is due to our own negligence in maintaining security.
In the old UCTA world, a court might look at whether you got a cheaper membership because of that risk. Under the CRA 2015, a court is far more likely to just deem that clause unfair.
Why?
Because the consumer has a reasonable expectation that the gym will provide a basic level of care and security. Excluding liability for their own negligence creates a significant imbalance in obligations. It's just not fair.
And if that clause is deemed unfair under the CRA, what happens to the contract? Does the whole thing fall apart?
No, and this is key. The rest of the contract stands, but that specific unfair term is struck out. It's just not binding on the consumer. So you get the benefit of the deal without being held hostage by the unreasonable fine print.
That's incredibly powerful.
It is, because it protects the individual, even if they didn't read or fully understand the clause when they signed up.
So that's a powerful 1-2 punch from the law. We have UCTA 1977 setting boundaries for commercial deals, especially against standard forms, forcing businesses to justify the reasonableness of their risk exclusion. And then we have the CRA 2015, which acts almost like a Bill of Rights for the consumer, voting any term that creates a significant imbalance.
It's the legislative synthesis that ensures English law maintains a balance. It supports the principle of freedom of contract, the ability to make your own deals, but it imposes these guardrails to prevent exploitation. These guardrails make sure that any risk transfer is transparent, justified, and ultimately fair.
So we started by figuring out what actually counts as a promise. The difference between a term leading to expectation damages and a misrepresentation that could lead to rescission. We then showed you the statutory defense mechanisms, UCTA and the CRA, that police the terms designed to limit liability.
And if we connect this to the bigger picture, this regulatory oversight really confirms that the fine print is not the final word. A contract isn't just about what you signed, it's about what the law allows you to sign. The law is actively protecting against clauses that would otherwise make fundamental protections totally meaningless.
That's a perfect summary of the landscape. So here is our final provocative thought for you to chew on until the next deep dive. Next time you see a limitation of liability clause, don't just ask, is this fair? You need to apply the legal filter. Ask yourself, am I a consumer or is this a business-to-business deal? If it's a B2C transaction, ask, does this term cause a significant imbalance against me, contrary to good faith? If it's B2B, ask, is this term reasonable given our bargaining positions and any benefit I might have received? Understanding which statute applies, CRA or UCTA, is the key to determining the true enforceability of the fine print. And that small piece of knowledge gives you immense power,